Welcome to Neat Law. Let's understand important clauses of contract. Before understanding clauses, let's understand what is a contract. First, a contract is an agreement between two parties which is legally enforceable and that is backed by law. For instance, let's say you agree to design a logo for a client, and they agree to pay you 5,000 rupees for it. That's a contract. If they ghost you after receiving the design, you can take legal action, because that promise is backed by law. Let's do a quick contract check. Did someone make an offer and the other person accepted it? Is there consideration, like money or service, being exchanged? Do both parties intend to create a legal relationship, not just a casual promise? Are they legally capable, not minors or mentally unfit? Was the agreement made with free consent, without pressure or lies? And finally, is the purpose lawful? For example, if A agrees to pay B 10,000 rupees to design a website, and B accepts, that's a valid contract. But if A pays B to hack into a competitor's site, that's not just invalid, it's illegal. Let's break down the 7 most important contract clauses you'll see everywhere, from NDAs to freelance gigs to business deals. This clause means one person clearly says what they're offering, and the other person agrees to it. Both sides must be on the same page. Example. You say, I'll design a logo for you for 5,000 rupees, and the client says, yes, I agree. That's a valid offer and acceptance, and the deal is made. The consideration clause explains that both parties must give or get something of value, like money, services, or goods, for the contract to be valid. For example, if you design a logo and the client agrees to pay you 5,000 rupees, that payment is the consideration. The confidentiality clause, on the other hand, makes sure that any private or sensitive information shared during the contract stays between the parties and is not shared with anyone else. For instance, if you're working with a brand on a secret project, you can't post or talk about it until they allow it. The termination clause explains how either side can end the contract if things don't go as planned. For example, if one party keeps missing deadlines, the other party might be allowed to cancel the agreement by giving a written notice, like saying, I'm ending the contract in 7 days. The dispute resolution clause tells both sides how to solve problems if they disagree about something. Instead of rushing to court, the contract might say they should first try to talk it out or go for mediation. For instance, if a client refuses to pay, both parties may agree to meet with a neutral person to settle it calmly before taking legal steps. The force majeure clause protects both parties when something unexpected and out of their control happens, like a natural disaster, war, or government lockdown. That makes it impossible to carry out the contract. For example, imagine a company promises to deliver event equipment for a concert, but just before the event, a sudden government lockdown due to COVID-19 stops all transport. Because of the force majeure clause, the company won't be held legally responsible for the delay, since the situation was beyond their control. Let's do a quick recap of what we learned till now. What is a contract? A legal agreement between two or more parties that the law will enforce. When is a contract valid? It needs offer, acceptance, consideration, legal intent, capacity, free consent, and a lawful purpose. 7 key clauses to know. Offer and acceptance. Consideration. Confidentiality. Indemnity. Termination. Dispute resolution. Force majeure. Found this helpful? Then you'll love what's coming next. Don't forget to follow Neat Law for more simplified legal content, straight to the point, and easy to understand. See you in the next one.